Hi everybody, welcome to the third lesson for Legal Studies 3-4. In this video, we're going to cover the court hierarchy, key personnel, sanctions, sentencing factors, and reforms. To start off with, at the top of the court hierarchy is the High Court of Australia. Below that is the Supreme Court Court of Appeal. Below that is the Supreme Court Trial Division, the County Court, and at the very bottom, the Magistrates Court. The Court of Appeal has no original jurisdiction. It only hears appeals. It hears all appeals from the County Court and Supreme Court Trial Division on a point of law, conviction, sentence, and point of law. The Supreme Court Trial Division has an original jurisdiction of the more serious indictable offences, such as murder, terrorism, treason. It hears appeals on a point of law from the Magistrates Court, which means cases which appeal the legal reasoning and the way that the law has been applied to the case. The County Court hears indictable offences which are less serious, such as assaults, some drug cases, some rape cases, and it hears appeals on sentence and conviction from the Magistrates Court. This is where someone is appealing the fact that they've been found guilty or the length of the term of their imprisonment. The Magistrates Court only has an original jurisdiction. It doesn't hear any appeals as at the lowest court in the hierarchy. It hears summary offences such as traffic offences, shoplifting, and indictable offences heard summarily, which we covered in the first video. It also hears committal proceedings, which, remember, are the pre-trial procedures heard in the Magistrates Court for indictable offences. One reason for the court hierarchy is appeals. Without the court hierarchy, there would be no way to determine which judge has the authority to review and change the decision of another judge. So more experienced judges in the court hierarchy can review and change the decisions of lower court judges. Another reason is precedent. Without the court hierarchy, there would be no system to determine which judge is bound by another judge's decisions. Lower court judges are bound by higher court decisions, but lower court decisions are only persuasive on higher courts. Another reason is administrative convenience. So cases are allocated based on the severity and complexity of the legal issues that they are hearing. And that allows the court to allocate certain types of resources to the courts that are necessary. For example, it would be unnecessary for courts to have a jury room in the Magistrates Court. And so jury rooms are only built for the county and Supreme Courts. This also ensures that the fees and delays are proportionate to the severity and complexity of the legal issues. If there was no court hierarchy and only one court that heard all different types of disputes, then it might mean that the court filing fee for a claim of case of a very minor issue was $10,000, which doesn't really make sense. Also, it would make no sense for a very minor issue, such as a traffic offence, to have a 2.5-year delay because it's being delayed by continuous, 6-week trials. So the fees of the Magistrates Court are proportionate to less serious offences, whereas the delays in the Supreme Court is proportionate to lengthy trials. Another reason is specialisation. So judges, because they hear similar cases in similar legal issues or similar crimes on a daily basis, they gain experience and expertise in that area of law. That allows them to hand down decisions more efficiently because they understand the law and they understand the court processes, but also more appropriate sanctions. Because remember, judges have to determine where on that sentencing guideline that case sits. So for murder, they have to determine, is it worth 6 months imprisonment or life imprisonment? If a judge has only heard, if a judge hears all different types of cases, they may not have a good way of determining where on that range it sits and if it's a serious murder case or a less serious murder case. But because judges in the Supreme Court have specialisation over murder cases, they can compare it to other cases that they've heard and determine that it's, in the upper middle bracket, so it should be worthy of 20 years imprisonment. And that's the same for Magistrates Court with traffic offences and summary offences. They're very specialised and experienced over less serious offences. Now we move on to the key personnel. So starting off with the jury is 12 members of the community randomly selected off the electoral roll. The jury must have no connection to the parties and remain objective to ensure that they're not presenting any favoritism to either party. The jury reach a shared decision regarding the accused culpability, so they determine the verdict for criminal cases. That means that the decision is spread across 12 people, which limits bias, as 12 people, it's unlikely that all 12 people would be influenced by preconceived ideas and biases. The jury has to listen to all of the evidence presented and follow the judge's directions. However, juries do not give reasons for their decision, so we're unable to determine whether they are affected by any preconceived ideas and biases. Another issue is that juries are not experienced in the law and they may not understand the legal arguments and the evidence presented. Juries also may have inherent biases due to their personal views and also the media. Remember that juries are only used for indictable offences. Next, we have the judge. The judge as an impartial arbiter, so they need to remain objective and present the rules of evidence and procedure in the same way according to both parties to ensure that they're treated fairly. The judge will ensure that the court processes are carried out and that parties' rights are upheld, also upholding fairness. They uphold the jury and direct the jury to ensure that they understand any legal arguments and all rules and evidence and procedure, and that they are not influenced by anything that is inadmissible in court. Despite the judge's legal expertise and experience, they don't overly interfere in the court proceedings. They can assist self-represented parties to some extent, but if they overly interfere, then it's cause for a mistrial and a retrial. And the judge's main role is to determine the type and the length of the sanction once the jury has reached a verdict. For magistrates, they determine both the verdict and the type and length of sanctions. So moving on to parties, we have the prosecution and the defendant or the accused. Parties have party control, so they can choose what evidence to present and what legal arguments are best to represent their party's interests. The prosecution also has the burden to discharge the burden standard of proof, and the prosecution should assist the court to reach the truth. Legal practitioners have to represent their client in the best light and assist the court at reaching the truth. Their primary duty is to the court and they cannot mislead the court. The defence has to defend the accused despite their personal beliefs or opinions regarding the accused's culpability. An issue with legal practitioners is that it increases the costs, and the accused may be disadvantaged if they cannot afford as high quality legal representation as the prosecution. There are two different types of legal practitioners: the solicitors, who prepare the legal documents and arguments, and the barrister, who then advocates for the party in court and presents the argument to the judge and jury. Moving on to sanctions. There are 5 purposes of sanctions. So the first purpose is to hold the accused accountable for their criminal behaviour. So to punish the accused is a notion of retribution. Protection is to safeguard the community from the offender. Deterrence, we have 2 different types: general deterrence, which deters the community from undertaking similar behaviours, and specific deterrence, which discourages the accused from reoffending. Rehabilitation seeks to treat the accused for any underlying issues causing their criminality, such as drug and alcohol treatment. And denunciation, which is where the court shows disapproval for the accused actions and shows that the community does not tolerate such behaviour. This is usually where the court will hand down more harsh penalties to reflect the denunciation. The first type of sanction is a fine. A fine is a monetary penalty imposed on the accused to be paid to the court fund. If the accused does not pay the fine, they can be imprisoned or forced to take community service. The purpose of a fine is primarily to impose a financial penalty as a punishment, but that depends on the amount. If the accused is very rich and is of a high socioeconomic status, a fine of a couple $100 is not going to punish them accordingly. But similar with specific deterrence, if the amount is not high enough, it will not prevent the accused from reoffending. As a general deterrence though, fines are pretty good at discouraging the community from undertaking behaviours. Speeding, a lot of people are discouraged from speeding because they don't want to incur an unnecessary fine. And denunciation, to some extent, its fines do show that that behaviour is not tolerated and that it warrants a penalty. But again, it kind of depends on the amount of the fine. If there's a certain type of behaviour which attracts a significant fine, thousands and thousands of dollars, such as breaking like the coronavirus orders, then that may show that the community and the court is denunciating those actions. And they do provide some protection in a way by discouraging undesirable behaviour such as speeding, but there's no rehabilitation. Next is community corrections order. Community corrections order is a supervised sentence which is served in the community where conditions such as drug and alcohol treatment or community service are attached. So it's non-custodial because the accused is allowed to remain in the community and go about their normal life to some extent. The main purpose is for rehabilitation, to encourage the accused to stop their criminal behaviour. However, if the accused does not comply with their CCO or breaks a condition, they will be imprisoned. A CCO is usually imposed for 2 to 5 years, and it's not for serious offences such as rape, murder, or manslaughter. The purpose is to punish the accused by limiting their freedoms. They can't leave Victoria, they have to attend meetings, they have to report to their officer. The main purpose is to rehabilitate the accused through drug and alcohol treatment, violence treatment, that kind of thing. There is specific deterrence because it forces the accused to undertake undesirable conditions, which may deter them from undertaking those criminal actions again. Very little protection because the accused is allowed to remain in the community. Little general deterrence because for the most part, the community think of it as kind of a lenient sentence. And it's, again, for that reason, there's little denunciation. Finally, imprisonment. Imprisonment is where the accused is removed from society with their freedoms and civil liberties limited, and they're placed in prison for a predetermined period of time. The main purpose of imprisonment is to punish the accused because they lose their freedom and civil liberties. It also protects the community by removing criminals from society. The rehabilitation is very minimal, and that's because of the high recidivism rates of 44%. And so that means that whilst there are some programs in prison, it's not enough. And a lot of the time, accused are reoffending once released. Denunciation is achieved if the sentence imposed is very, very harsh. So if the judge goes to the upper end of the sentencing scale, then it's usually achieving denunciation. Whereas if someone got like 6 months for murder, that would not be seen as denunciation. General deterrence is very, very high. Most of the community is not wanting to go to prison ever. And again, specific deterrence is not always achieved, again, due to the high recidivism rates. Now moving on to sentencing factors. So these are the things that the judges consider when determining what an appropriate sanction would be for an accused. Aggravating factors are things that the judge would consider that increase the severity of the accused actions and the seriousness of the offence. Things such as the accused being extremely violent, using weapons, committing crimes against vulnerable victims such as children, elderly, disabled people, if it's motivated by prejudice such as terrorism, and whether the accused was on a community corrections order at that time. They're all going to push the sentence up to the upper limit of the sentencing guideline. Mitigating factors, however, reduce the severity of the sentence and the severity of the accused's actions and the seriousness of the crime. Things such as showing remorse, complying with police, having no prior convictions, and prospects of rehabilitation. They're all things that the court will consider, and that may mean a less serious penalty is imposed. The judge will also consider whether the accused has entered into a guilty plea. The earlier the accused pleads guilty, the greater the sentencing discount, because of the fact that it saves the parties and the court a lot of time, money, and stress. And therefore, the accused is rewarded and the court will take something off their sentence. Victim impact statements can also be considered, and that's where the court will take consideration the impact of the accused actions on the victim and their families. And that will usually also act as an aggravating factor because the victim will talk about the significant consequences of their accused actions. And the judge will usually respond to that in a way which is undesirable for the accused. The last little bit of this area study is not a lot of content, but it is something just to have in your notes. So sometimes it might say evaluate the factors that affect the criminal justice system. I think it's good to have one thing that is a barrier and one thing that's an enhancement. These are all things you've learned throughout the area study, so you don't need notes on them. Just to have them in your notes as this, like a sentence on what you talk about, is more than enough. So for something that increases costs, legal representation, and you talk about why, and how it reduces equality and access. Cost enhancements is increased access to self-represented parties through Victorian legal aid and community legal centres, and you talk about how they achieve the principles of justice or how they don't. Time barriers is court delay, so you talk about essentially the court hierarchy and how it, how the court hierarchy reduces delays. And then for your court delays, you talk about how it's inevitable that there are delays in the court system, coronavirus, all that kind of thing. For your time enhancement, you could also potentially talk about, for time barriers as well, sorry, you could talk about your pre-trial procedures like committal proceedings, potentially sentence indications if the accused doesn't accept it. And for time enhancement, I'd be focusing on the court hierarchy and the administrative convenience, the fact that cases are allocated based on a similar kind of length. And that means that smaller cases aren't pushed back by longer cases. Cultural barriers is problems during questioning, giving evidence. And you just talk about the fact that people of different cultures and ethnicities may have issues understanding the evidence presented. And the cultural enhancement is your interpreters. Finally, 2 recommended and 2 recent reforms that you can look into for this is, first, for recommended reforms, abolishing committal proceedings, and you talk about why, the issues, the weaknesses of committals that are in the previous video. Trial by judge alone and the removal of juries, and you talk about the issues with juries that we spoke about earlier in this video. Finally, recent reforms, the expansion of the career court. An example would be in Mildura in 2016. I'm sure there are more recent examples. And also the time removal of jury deliberations. There used to be a set period of 6 hours, which they removed in 2017. So that brings us to the end of Area Study 1, and I hope to see you in the next video.